already discussed with Amendment 17. Is Amendment 23 agreed? Agreed. Amendment 24 is already discussed with Amendment 17. Is Amendment 24 agreed? Agreed. Amendment 25 in the name of Senator van Turnhout and McConaughey arises out of committee proceedings. Senator van Turnhout.
Thank you very much. Welcome, Minister, back to the House for report stage, what has become now, I think we could all call, a very comprehensive bill. At committee stage last Wednesday, I outlined in great detail the rationale and urgency behind the amendment I proposed, and I don't propose to do so again today because we're all here. Minister, as I hope was clear from that intervention, I have conducted extensive legislative analysis around my proposal, which I believe strikes the appropriate balance between the right of the accused to procedural fairness and the right of the child witness to privacy and personal dignity. It is difficult, without ready access to legislative drafters, to translate a legitimate and necessary reform such as this into a legislative proposal, and I thank you, Minister, for your critiquing of my amendment at committee stage. It's given me this opportunity, albeit with an extremely short turnaround time, to now revert with a more robust amendment that I urge you to accept here today. Your primary concern regarding court procedure is very valid. I've altered the wording to allow the matter to be considered pre-trial. I've also added a reference to the rule of court to allow for further regulation of the application process by way of an amendment to the rules of court, should you or the Court Rules Committee find it necessary to do so. For example, the rules could set out a prescribed form for such applications, time limits and so on. Minister, I noted your concerns around the qualifications of a counsellor and clarity as to whom communication should be regarded as confidential. I believe it's unwise to specify any particular credential for counsellors. This is partly because of the wide range of training and education approaches in the area. But more important is the avoidance of a situation where communication made by a child in confidence is disclosed simply because the counsellor didn't pass all of the exams or passed the wrong kind of exams. The question of regulation of counselling profession is an important one, but there is a danger of allowing a preoccupation with credentials to distract from the purpose of this amendment. However, to address your concern, I've added the following short provision, which allows you to refine, by way of statutory instrument, the definition of counselling and counsellor, whilst allowing the amendment to proceed. In the amendment I propose, it says the Minister may, by order, set out detailed criteria regarding the conduct of sexual assault counselling and the training or qualification of those who provide sexual assault counselling for the purpose of this Act. I also noted the points you made with respect to the word encouragement, and while I believe it is a remote concern, I've removed the word from the section. Minister, I do thank you for your letter subsequent to committee stage debate, and I'd like to address some of the points you raised therein. You have said that any proposal in this regard should address the rights of an adult as well as child complainants, and that immediate action is required, and as such you've decided to deal with the issue in the forthcoming Sexual Offences Bill. You will recall, Minister, in my committee stage intervention that I also stressed the urgent need to address the issue of third-party disclosure of confidential records for adult complainants. I know that there is a considerable amount of work being done by interested members, including myself and Senator Batchik, by advocacy groups already, and I welcome your commitment to act in this regard. However, I don't see any justification for not proceeding with legislative solutions for children immediately, as in here and now in this bill, as opposed to immediately in the future in the Sexual Offences Bill, for which the heads have not yet been approved by government. You know, Minister, in February 2012 I brought forward a motion on the issue of child abuse material, and at that point I was promised that it would be in the Sexual Offences Bill, which will be coming shortly. So you can understand, I trust you, but the issue is that this is a very real and pertinent issue that is being dealt with children at the moment. Minister, every child has the right to protection from harm, abuse and exploitation, including from criminal justice arrangements. As an aside of sorts, there is another issue I feel I must raise in the wider context of the experience of child victims of sexual abuse and the criminal justice system, about repeated interviewing by separate agencies, most commonly in the context of parallel Garda investigation alongside a child protection investigation. And the attendant risk of further trauma and upset for a child in this context can be avoided by joint interviewing, which I know is done in other countries. Also, from a legal perspective, limiting the number of times a child is interviewed will reduce the potential for the type of contamination of a child's recalling of events that can lead to the failure to secure conviction. Minister, what we need in this jurisdiction, I believe, is effective coordination and training of Garda and social workers interviewing child victims of sexual abuse. And I do note the arrangements in place for this in our neighbouring jurisdictions, such as the UK, achieving best evidence video interviews and the detailed recommended practice for interviewing child witnesses in the latest edition of Achieving Best Evidence in Criminal Proceedings, guidance on interviewing victims and witnesses, and guidance on using special measures and guidance on joint investigative interviewing of child witnesses in Scotland 2011. But back to the substantive point, and in ending, I've already pointed out that there's been a notable increase in requests from the DPP's office seeking access to therapist notes of children's private and confidential therapy sessions over the last 6 to 12 months. So it's a very real issue in the now. As an independent office, I appreciate that you cannot directly instruct the DPP to revise its practice in this regard, so I believe there is no time to waste in introducing legislative guidelines. I also appreciate the need for a solution that is workable from a prosecutorial and a defence perspective, and I argue, as I did at committee stage, that the arrangements proposed do not affect in any way the disclosure of material evidence or evidence relevant to a criminal trial. The issue has been raised on a number of occasions, most prominently and recently in 2010 by Dr. Jeffrey Shannon, who is the government-appointed Special Rapporteur on Child Protection. He stressed the urgent need for legislation then. That was 3 years ago, and no legislation has come forward. Minister, I don't have the legislative drafters that you have at your disposal and the advice that you receive. I don't need it to be this amendment today in the Seanad. But for me, for a bill that is in the distance, even if it's in the near distance, for me it's not good enough, because this is about children at the moment whose records are being handed over. You have parents telling me they are not sending their child to counselling because of this situation. We have an obligation, I believe, to do something. And I appreciate, Minister, you understand as much as I do on this issue, probably more so from dealing with cases. But for me, I have put this amendment forward in good faith, and I really have tried to get the balancing right. And I'm willing to go back and work, and if it has to be brought through in the Dáil, I have no difficulty. It's not about my name. It's about the children in these cases. We've seen the increase in the DPP requests in the last 6 to 12 months. This issue is escalating rather than going away.
Senator Clardy, you are going to second the amendment.
Yes, Harley Boylan, could you listen to Malta? I'd like to second the amendment. I think it's. I was actually quite disappointed, Minister, that we had a very, very fulsome debate on the issue last week, and I was actually hoping that you might bring forward an amendment yourself on this issue, because I think it was done in good faith, and I think that last week Senator van Turnhout showed that she'd done a huge amount of